Good morning, everyone. I hope everyone had a good night's sleep last night. And welcome to the IP High Court of Korea. It's a huge honor to have distinguished guests here. We are going to have a very engaging session this morning, session 5, which is case discussion on IP injunction. As this session deals with highly important issues in today's IP disputes, I'm confident that the discussion will maintain a high level of interest and interaction. We are going to have an in-depth discussion on IP injunction using real cases. Session 5 will run from 10 o'clock to 12:20 with a short break in between. And this session will be conducted in English. Now I'm delighted to introduce the session's moderator, Honorable High Court Judge Young-gi Kim of the IP High Court of Korea. Please join me in welcoming him.
Hello everyone, how's everything going today? Hopefully all of you are enjoying this gorgeous weather as well as this conference. I am a young Judge Young Kim from this IP High Court of Korea, which is the very first IP specialized court in Asia. Actually, I'm very proud of it. And also welcome to this very brand new session, which is newly launched at this conference, and which cases were recommended by our panel. And interestingly, in each case, SCP holders moved for get the injunctive relief. However, the German court and the US court have reached a different decision, of course, based on the different fact-finding. I'm sure that it will provide us the best opportunity to compare IP injunction practices among the major IP4 countries. Especially, I appreciate Judge KLEIN and Judge CHANG for recommending these meaningful cases. Thank you, judges. Okay. Oh, wait a second. Yes. Now, let me introduce the renowned panelists for our session. For this session, a whole collection of amazing people have joined us. Firstly, always lady first, Judge Anna-Lena KLEIN from Regional Court of Munich 1. Good morning, Judge. Okay. And next year, we have Judge Edmond E. Chang from Northern District of Illinois. Judge, did you take some rest last night? Okay. Okay, great. Next, we also have Judge Yoshiaki SHIBATA from Tokyo District Court. Good morning, Judge. Okay. Last but not least, we also have Judge Kwon Bo-won from this court. Yeah, we also wonderful case briefing attorneys from KIPLA. Firstly, Mr. Ki-jung Kim at KLEIN. And next to me, Ms. Haewon Chang at Kim & Chang. They are for German case. And we do have Mr. Sang Tae-jung at Yulchon. And we have Mr. Jung-Eun Hong at Lee & Co. They are for US case. Okay, for your convenience, our team prepared a summary of the case. So please refer to the reference book on page 343 for Korean and 333 for English. 343, okay? Okay. Now I think it's time to open the case with the briefing from Mr. Ki-jung Kim. Mr. Kim? If you're ready, please proceed.
Good morning, everyone. My name is Ki-jung Kim, a partner at law firm KLEIN. Together with Ms. Haewon Chang at the law firm Kim & Chang, we prepared the presentation of this case, Nokia v. Oppo. The case involves interesting discussions about Article 139 of the German Patent Act, which provides that injunctions may be denied for disproportionality. So without further ado, let's begin by introducing the parties involved. On one side, we have Nokia, a well-known entity that owns SEPs on wireless telecommunications. And on the opposite side, we have Oppo. What a perfect name for the opposite party. Manufacturer and seller of smartphones that implement these standards. After Nokia and Oppo had previously entered into a license agreement. And after expiration of the license and failure to agree on further licensing terms, Nokia filed an infringement suit against Oppo before the Munich District Court. Nokia alleged that Oppo's 4G compatible smartphones violated their patent, which relates to processing audio signals. Unfortunately, due to time constraints, we have to skip what the technology is about. I just want to note 2 points. First, this is a standard essential patent, so there is going to be some discussion about FRAND obligations and its relation to Article 139. And second, if you ever try to understand the technology and feel frustrated, you are not alone. So fast forwarding to the part that we are all gathered here for, the legal issues in this case. First, did Oppo infringe Nokia's patent? And second, was there an abuse of power by Nokia as an SP holder? Or was Oppo an unwilling licensee? Third, is there a substantial likelihood that the patent will be invalidated? And if so, should the infringement proceeding be stayed? And lastly, should an injunction be imposed under Article 139? Would such an injunction be disproportionate? I'll walk you through the parties' arguments and the court's decision on these points. Let's look at the parties' main requests first. Nokia sought injunction and damages against Oppo. In response, Oppo requested that the action be dismissed entirely because, of course, Oppo did not infringe the patent. Alternatively, Oppo suggested a pause on the legal proceedings pursuant to the German Civil Procedure Act because there was an invalidation action on the same patent. Lastly, Oppo pleaded for the exclusion of the injunctive relief due to its disproportionality. As for the disproportionality, Oppo asserted that the injunctive relief would cause excessive hardship. Oppo also accused Nokia of misusing its dominant position. Nokia argued they've maintained good faith. Nokia categorized Oppo as an unwilling licensee. These are the outline of the parties' arguments. Now, let's look into the court's reasonings and rulings. The court found infringement of the patent, although I think it would be very interesting to compare the law of indirect infringement across different countries. Again, due to time constraints, I'm afraid we have to fast forward to the main topic of this session. So now we know that Oppo infringed the patent. Would the injunctive relief be disproportionate? According to Article 139 of the German Patent Act, a party who infringes a patent may be sued for cessation. However, this right is subject to the principle of good faith. This right is negated if it would lead to unjustified hardship for the infringer or third parties. The court made a few noteworthy remarks on this provision. First, the defense based on Article 139 is allowed only under exceptional circumstances. The burden of proof to demonstrate disproportionality rests on the defendant. And second, as long as the patent holder meets FRAND obligations, the article does not provide the defendant with any additional defense. And third, the SEP holder is obligated to negotiate licenses according to its FRAND declaration and antitrust law. So the mere fact that the SEP holder seeks injunctive relief is not in itself an indication of disproportionality. Fourth and last, in FRAND cases, the complexity of the product, or in other words, the fact that the product includes many other parts irrelevant to the infringement, does not weigh toward disproportionality. Now let's dive a little bit deeper into the factors the court evaluated in this case. The court found that all of the factors leaned toward granting the injunction. First, the fact that Nokia is a non-practicing entity did not in itself lead to a finding of disproportionality. Since Nokia is bound by Friend Declaration and antitrust law, the fact that Nokia had been licensing patents and did not implement the patents for themselves should not be held against Nokia. Second, about the undue hardship on Oppo. Oppo had been using the patent for a year without compensation, so there was no undue hardship caused by the injunctive relief. That's what the court found. And third, Oppo refused Nokia's offer that was not completely unacceptable. Therefore, the complexity of the infringing product does not prohibit Nokia from seeking injunction. Lastly, Nokia's position was strengthened by the fact that Oppo was an unwilling licensee. The court also referred to a prevailing opinion in the academia, which was if the SCP holder adheres to its friend obligations, Article 139 doesn't grant any additional defense for the implementer, unless there are other circumstances evidencing disproportionality. In addition to the defense based on disproportionality, Oppo alleged Nokia's violation of friend obligations. However, the court favored Nokia on this issue as well. According to the decision, abuse can arise if the SP holder obstructs products from accessing or remaining in the market. In more detail, the SP holder's actions would not be abusive if the SP holder informed the implementer of the infringement and the SP holder provided a friend license offer to the implementer that showed willingness to license, and if the implementer, while using the patent, still using the patent, did not diligently respond to the offer. And on the other hand, it can be abusive if the SCP holder did not make enough effort to engage the implementer or deny the friend license despite the implementer's efforts. While making an offer with non-friend terms is not abusive by itself, refusing to negotiate and conclude a friend license agreement can be abusive. So both parties must play their part to successfully conclude a licensing agreement. That said, the implementer's behavior seems to be a little bit more important. The court held that the implementer must be eager and clear in its intent and its behavior to finalize the friend agreement. Then was Oppo an unwilling licensee? The court saw delaying negotiations as an indication of unwillingness. An implementer is only released from responding to an SP holder if the offer is so far from acceptable that it essentially amounts to a refusal. Finding that Nokia's offer was not such a case, the court determined that the lack of detailed royalty calculation in Nokia's offer did not render it unacceptable. What mattered was the communicated amount resulting from the underlying calculations. On the other hand, evaluating Oppo's conduct, the court observed that Oppo only raised objections during court proceedings, and their proclaimed readiness to license was contradicted by their actions because Oppo's exchanges with Nokia seemed to be designed more to delay than to conclude a license agreement. And despite ample time and opportunity, Oppo did not take adequate steps as expected by business practices and good faith. So in conclusion, the court determined that Oppo was an unwilling licensee. Lastly, let's look into Oppo's request to suspend the proceeding. The court found that the right to enforce the patent should be respected given the limited duration of the patent. In essence, suspending an injunction proceeding may amount to a de facto suspension of the patent right itself. Therefore, the suspension can be considered only if there's an overwhelming probability of the patent being invalidated. In this case, since the patent at issue is novel and inventive compared to prior arts, the court denied to stay the proceedings. So in conclusion, the court found that Oppo infringed the patent in question, and Nokia did not exploit its dominant position as an SCP holder. Conversely, Oppo was perceived as an unwilling licensee because Oppo used delaying tactics when Nokia's offer was not completely unacceptable. And the patent, since the patent was unlikely to be invalidated, there was no warrant to suspend the infringement proceedings. And lastly, granting the injunction is not disproportionate, considering the nature of the defense as an exception to the principle. So my briefing of the case ends here. I want to express my appreciation to Ms. Haewon Chang for this wonderful material. Now I will hand over the mic to our moderator. Thank you.
Thank you very much, Mr. Kim. It was great. And by the way, Ms. Chang, I know you also contributed a lot to this case briefing. And what is the current status of this case? Did Oppo appeal against this decision?
This case is appealed to the High Court last year. So as far as I know, it's still pending.
Okay, great. You're always great. Okay, now let's launch the journey of our discourse through the issues in this case. For the smooth discussion, judges, within the restricted time schedule, it would be really nice of you to make your comment normally within 2 minutes. But it's flexible, okay? Good. The first issue is proportionality and standard essential patent. The first question goes to Judge KLEIN. Okay, actually she was at the bench for this case, you know. In this case, 3 factors were examined with this issue. First, whether the plaintiff, as the SCP holder, complied with its friend commitments to the SSO. Second, whether the plaintiff abused its dominant position in violation of European and German antitrust law. And the third, whether granting injunctive relief to the plaintiff would be disproportionate. Question. Judge KLEIN, were the first and the second factors analyzed in relation to the disproportionality defense, or were all issues examined separately to decide upon the issuance of injunction?
Thank you. First of all, let me express my gratitude to Mr. Kim and Ms. Chang, because actually I know that those decisions are a lot to take in, and you did a fabulous job of really summarizing them. Thank you so much. Now, relating to your question, I would say that generally those aspects are 3 different aspects. You have to consider them separately. They have different legal requirements and different legal consequences. Now, in this case, we always look into the defense as it is presented to us. We did very briefly look into the issue of contractual obligations stemming from the SSO declaration, but this was not the focus of the discussion of the parties, so it's just mentioned in one paragraph in the decision. So we focused on the antitrust issues, the front defense, and then the disproportionality defense. And again, those are different defenses, but of course they intertwine. And Mr. Kim, you mentioned 2 aspects. If you look into the behavior of the patentee, you will see that on the one hand, he is obligated to hand out a license under the front defense, and on the other hand, you could hold it against him under the disproportionality defense. If you say you're only interested in taking a license, then you shouldn't be able to get an injunction. And here we decide, well, you have to look at the whole picture. You can't really separate those 2 totally. You have to look at the whole picture, and then you can't hold it against him that he is willing to give a license where he's obligated to give a license under friend issues. And the same goes for the defendant side. If the defendant is not a willing licensee, then it's on him that there has not been made a license deal yet. If there would be a license deal, then, well, we wouldn't talk about disproportionality at all, because then the patent use would actually be lawful. So again, you have to look at the whole picture. Where it's on the defendant that there has not been made a license deal yet, generally you will need really exceptional additional circumstances to have a successful disproportionality defense. Thank you.
Okay, thank you, Judge Klein. Then you mean that the three factors are separate, but you consider them totally, right?
Yes, we have to look at the requirements and the consequences separately, but you must always take into account that you have to, well, in the end, there's just one action that the patentee takes. He must give a license, so you must look at the whole picture and really, find a difference.
Okay, then the next question goes to Judge Chang. If this case were brought before your court, would you examine and determine the three factors as separate issues? If not, how would you examine those factors to determine whether to grant an injunction in the United States?
Yeah, thank you, and also thank you to the case briefers for the excellent job, and on the case briefers for the Microsoft versus Motorola case. Also did an excellent job. You have a lot to look forward to when they make their case briefing as well. In the United States, the antitrust issue in the first instance would actually be considered at the liability phase. Of course, there's infringement, but in the United States, patent misuse, right? When a company uses a patent in a way that violates antitrust law, that actually is an affirmative defense that if the defendant proves it, there is no liability at all. And so we would not even consider an injunction because the patent owner would lose on the merits. The defendant does bear the burden of proof, of course, because it is an affirmative defense. On the FRAND commitments and disproportionality, those would be relevant to whether we would issue an injunction. For the FRAND commitments, we would examine whether or not there is a licensing rate that is fair and non-discriminatory, and that would typically suggest to us that there is a way to adequately compensate the SCP owner with money damages, and so an injunction would not be necessary. And you'll recall that one of the elements that in American courts that must be proven by the patent owner is that there is no adequate remedy at law. And disproportionality in American courts, we consider those under the balance of hardships and the public interest factors that U.S. courts must examine before issuing an injunction. And those are required considerations. This is an equitable principle that the Supreme Court has announced repeatedly, and also again in eBay versus Merck Exchange. So that is required, and indeed the patent owner must prove that the balance of hardships favors an injunction, and the patent owner must prove that the public interest would not be undermined by the issuance of an injunction. And I believe that sounds like it is different from Germany, where the defendant has the burden of proof on disproportionality. That's not the case in the United States.
Okay, yeah, we can find the difference between the U.S. and the German, right? Germany. Okay, good. And also in the United States, as an affirmative defense, the antitrust defense is very strong, right? It makes it unenforceable, the patent.
Right. It means that the patent owner is completely lost on the merits, and we will not even consider an injunction at that point. Okay. It is very strong, but it is, I know I'm way
very
past
hard
my
to prove, right?
Yeah, it's very hard to prove, so it is very rare. And it's only been seriously presented to me on one occasion, and I found that it had not been proven.
Okay, great. Thank you, Judge. And I want to give some slightly different question to Judge Shibata. The defendant in this case contended the plaintiff's patent, being an SCP, was ineligible for an injunction. The court, however, dismissed the argument, referencing the parties' negotiation history. As we heard at the briefing, the court mentioned the following disproportionality factors. First, interest of the patent holder, economic effects of the injunction, the complexity of products involved, and the first, subjective perspectives of the both parties, the last, interest of third parties. Now, question goes, when an SCP holders seek injunctive relief in your jurisdiction in Japan, aside from examining SCP holders' compliance with FRAND commitment, how do standards differ from SCP and non-SCP in the context of injunction matter? Judge Shibata?
Thank you all. And yes, Japanese court may consider these factors. So as I said yesterday, the court finds likeliness of infringement or infringement, court grant an injunction, but there is an affirmative defense of abuse of right. And when the court examined the defense of abuse of right, court examined these factors, instead of patent holder, economic effects of injunction, and complexity of product involved, and other issues. I think factors as interest of patent holder or economic effects of the injunction or the complexity of product involved is very different between safe and not safe. So in this, from this point, safe and not safe is different when we considering the granting injunction. But yes, so but there is only factors. So we consider these factors comprehensively. So and also the burden of proof bears the defendant. So,
Okay, Judge. Then in Japan, whether it is abusive of right is not or not is very important, right? And by the way, in any way, the SP factor characteristic weighs against granting the injunction in some way?
Yes, I think that the factor of against the injunction, but we consider many things comprehensively. So I think SAFE doesn't itself lead to dismissal of injunction. So we consider many factors.
Okay, thank you. Judge Kwon, could you give us any comment from Korean court's perspective?
Yes, it is difficult to say that there are many cases regarding on injunctions related to SCPs. So please consider filing suits in the Korean courts. but I think the decision rendered by Seoul Central District Court in Samsung versus Apple would serve as a good reference. The court held that the mere fact that a patent is an SCP or the patentee has declared a front or rent commitment does not inherently or automatically preclude the patentees from obtaining an injunction. But the decision assessed a balance between the parties by analyzing the negotiation history, the state and practice of the relevant market, and the overarching public interest. It could be said to be different factors to be considered in SCP cases. And this assessment included an evaluation of potential anti-competitive effects and the objectives of patent law and policy. So, as in other countries, the Korean courts also undergo comprehensive assessment. I'd like to mention another case on administrative law case. It was suit filed by Qualcomm against the decision of Fair Trade Commission. So it's not directly an injunction case. In this case, the Seoul High Court considered whether the licensing method was consistent with customary trade practices, so-called no chips, no license.
Yes.
The fairness of
No license, no chips.
No license, no chips. The fairness of the negotiation process and terms, in particular, the royalty rates and transaction terms, whether there was a violation of the reasonableness factor and non-discrimination aspect of the front commitment. So in some Korean courts conduct a comprehensive review.
Okay, Judge Kwon, you mentioned that there was not that much SCP case in Korean court. However, these days it's attracting a lot of attention, right? Even in Korea. Look at that, audience is there. So I have some follow-up question for you. In an SAP case, it's often the patent portfolio, including foreign registered patent, that is the subject of royalty negotiation, not just one patent registered in foreign country. So with respect to determining the appropriate royalty rate complying with friend commitment, the cross-border issues such as the appropriateness of assessing the royalty amount, invalidity, and value of those foreign registered patents could be raised in Korean court. And this may bring a jurisdictional challenge or related debate. Judge Kwon, would you please introduce the Korean practice or the recent amendment of private international law relating to this matter?
Yes, in Korea, traditionally or in principle, the courts have focused primarily on domestic patents and their impact, domestic impact. So foreign market impact was considered limitedly. However, a potential paradigm shift has been introduced by the recent amendment to private international law, which became effective from July 5th of 2022. There are not many cases regarding the amendment, but the updated Article 39, paragraph 3 provides that if the principal infringement of IP rights took place in Korea, a lawsuit can be filed for all results of the infringement, including those that occurred abroad. So this amendment may lead to the development of the legal framework. However, Korean judges are so accustomed to focusing on domestic impact that there are debates on how this amendment will really be applied or how the jurisprudence will develop. But this gives a potential that damage from the abroad would be considered in Korean decisions. But I think the abroad impact should have causally and very closely related to the domestic infringement, because it mentions principal infringement should be happened in Korea.
I think you already touched the damage issue, but if I echo or add something to the amendment of international private law, the amendment mainly relate to the international jurisdiction. So from now on, I think the Korean court might have some more active attitude towards the patent portfolio issues for some jurisdiction issues. Okay.
To add one thing, there was a Supreme Court case regarding because you mentioned about jurisdiction, there was a case the plaintiff sought for anti-arbitration suit, and the Supreme Court decided that this was not allowed in Korea. But these days, the legal framework or landscape is pretty rapidly changing, so we should watch.
Let's see what happened after the amendment. Okay, let's move to next issues. I prepared these NP-related questions, but I want to skip it because yesterday we already handled this issue deeply. NPE, non-NPE, doesn't matter, right? Okay, the third issue is antitrust objection. Also, this issue will be opened by the answer of Judge Klein, you know, right? In this case, the defendant argued that the plaintiff's request for injunctive relief amounted to an abuse of dominant position forbidden by European and German antitrust law. Nevertheless, the court disagreed with the argument. You disagree with it, right? And could you elaborate on the foundation of the decision on this specific matter? You may include the negotiation model established by CJEU, as well as the following decision by German Federal Court of Justice, please.
Well, you mentioned the framework that we had to work with. We first set out the framework, and Mr. Kim, like I said, expertly summarized it. We do have Article 102 of the TFEU to think of, and both the CJEU, the Court of Justice of the European Union, in their decision Huawei versus ZTE, as well as the Federal Court of Justice of Germany, in their decisions Friend Defense 1 and 2, gave us the legal framework to work with. Now, the CJEU established a negotiation model, and the Federal Court of Justice certainly elucidated that. And you mentioned, Mr. Kim, what this negotiation model is about. Both parties must play their role in this negotiation model. And I think the Federal Court of Justice expressly puts a strong emphasis on the willingness to take a license by the patent user. Now, what they also say is, who is to find the friend trade? In the end, in most cases, the parties discuss several conditions of the contract, but in the end, they will discuss and debate the friend rate. And so, who's the best one to set a friend rate? Is it us, the courts? Is it experts? As we understand it, the Federal Court of Justice says, no, it's the parties. It's the parties who should find the rate by negotiating.
Okay.
And so that's really the thing. And one thing I would like to stress also, and I think we might have a slight difference there to the US, is that the first offer that has been made by the patentee is merely the starting point of negotiations. So we don't have a one-shot approach, as maybe the US have. Mr. Chang will probably elaborate on that. But it's merely the starting point, unless the offer is so completely unfriend that you're not supposed to take it seriously, and then you need not react as a patent user. But unless it's so completely unfriendly, you need to react. Thank you.
Yes, unless it's unless it's completely unacceptable. It's a very impressive expression. Okay, thank you. Okay, and then these questions goes to the three of judges. Judge Chang first. In your jurisdiction, is the defense of antitrust commonly invoked in SCP-related cases? Considering the factual case, could you elucidate the likely conclusion in your jurisdiction along with underlying reasons? That's a difficult question, but yes.
Well, as I noted before, patent misuse based on antitrust, an antitrust violation is, in my personal experience, very rare. I look for data on this. We do not have data on how often patent misuse is asserted in SEP cases. But my personal experience is that it is very rarely advanced in any kind of patent case, let alone an SEP case. Here I think I'm always hesitant to try to decide a case without giving lawyers a chance to brief arguments under American law. But having said that, all I see on this record is that Nokia just did not arrive at a licensing rate, and they didn't do anything wrong. It seemed like, and there's no general rule that it's just a start. The opening offer by the patentee is just it has to be only the start. But I think we typically expect that there's going to be negotiation to show the good faith attempt to arrive at the rate. But here on this record, they just didn't get to a rate. It doesn't seem like they did anything wrong. And so if that's the case, then it would be very difficult for Oppo to show that there was patent misuse. Now, and the last thing I'll say on this is that, of course, because of our extensive discovery, Oppo would have been able to obtain, or at least ask for, every email, text, instant message, or record, that reflects the internal discussions of Nokia on this negotiation, and maybe that would have uncovered, something. So that might have altered the factual record. But as it is, it didn't seem like Nokia has done anything wrong.
Okay, great, thank you. How about in Japan's perspective?
So also it's very difficult to answer. So there are so many there are not so many safe cases, but the defense of antitrust can be invoked in safe-related cases also in Japan. And the defense of antitrust is a defense that bears the burden of proof, bears the defendant. In Japan, there is a case in which the defense of antitrust succeeded, but that case is unfortunately not the case, not the safe-related cases. So I don't say anything based on precedents, but in my personal impression, I think in this case, seeking injunctive relief itself may not be the abuse of the dominant position, and other factors related to dominant positions are not clear. So, I think in my personal opinion, it seems that Nokia didn't abuse its dominant position, so the defense fails.
Okay, thank you. We all know that judges are very cautious to give very clear answer, right, in a short time. Okay, Judge Kwon, could you give us some quick comment about this matter?
Yes, I would say in Korea the defense of unfair competition is pretty often invoked in SEP cases. They were, I mentioned two cases earlier, and both in Samsung versus Apple and Qualcomm cases, this anti-competitive defense was pretty deeply considered. And in Samsung cases, in the Samsung versus Apple case, the Seoul Central District Court rejected all claims suggesting Samsung's actions amounted to abuse of dominance. On the other hand, in Qualcomm case, no license, no chip policy were found to be inconsistent with brand commitment.
Yeah, you mentioned it before, right? Okay. Judge Klein, are you happy with their answers? You made great decision, right? Okay, they agree with that. Okay, great. Then let's move to next issue. The procedural suspension pending invalidity proceeding. I'm very sorry, but I cannot but start this question with Judge Klein again. Yeah, okay. In this case, the defendant sought to stay the injunction proceedings, referencing on ongoing third-party invalidity challenge against the plaintiff's patent. Nevertheless, the court dismissed the defendant's request, stating that a stay could only be considered if the invalidity is anticipated with overwhelming probability, right? Okay, then with respect to this issue, could you kind of explain the recent amendment of Section 83 of Patent Act in Germany and any changes in practice relating to this matter, please?
Yeah. Yes, there actually are. Mm-hmm. So as I've learned, you have in Korea a bifurcation system, and we have the same system in Germany. So basically, my court, the infringement court, will only decide that it's infringement, and the validity issue will be decided at, for instance, our German patent court. Now, but we do need to decide if we stay the case, if we think that it's very highly probable that the patent will be invalidated. Now, there used to be a so-called injunction gap where the infringement courts were very fast to decide in a year or so after filing of a suit, and the patent court took much longer. So there was the possibility that you would actually get an injunction on a patent that was later found to be invalid. Now, I've heard from attorneys that this bifurcation gap or injunction gap was actually a good thing about the German system. I think it depends on who you ask, on the perspective, because obviously for the defendants it was a bad thing. Now, the patent court used to give a certain communication to the parties preparing their hearing. So at a relatively late stage in the proceedings, after 1.5 years or so, where the parties had already exchanged several briefings. Now, this system is changed under the amended Patent Act. There must still be the communication, but it must be relatively early in the proceedings, 6 months after filing of the invalidity suit. So relatively early. Normally, 2 briefs will be exchanged. And for us, obviously, it's very helpful to get this communication. Normally, it will mean this this much earlier communication will mean that before the hearing, we will have this communication from the patent court. At least before the announcement of a decision, we'll have this communication. And obviously, the patent court is where they have technical experts in the field. So they are technicians, and we are only legally trained judges. So this gives us much more insight into the patent, actually, and into the prior art that we have to look at. So it's very helpful, and those communications are very thorough and very, very good. Now, what the patent court also does is they look at auxiliary claims. So if the patentee is served with an invalidity suit, they may communicate certain auxiliary requests to the patent court, stating that if the patent is granted does not hold, then we could limit our claims in a certain way as to, well, evade prior art, and then we could look at those auxiliary requests. And if the patent court, they would go through all the requests they've gotten under the communication, and then they might say, well, patent is granted, might not hold, but auxiliary request 4 will hold. And so the patentee can actually amend their infringement claim to this auxiliary request. So I guess we will wait and have to see if there's much change in the end, because the communication now comes much earlier than it used to. But I think for us, it's really helpful.
Okay, Judge, did you say auxiliary request?
Yes. Very hard to pronounce, I'm sorry. Auxiliary request.
Auxiliary, okay. I'll look up it later. By the way, I want to just correct a very small thing. Until 2015, we also had bifurcated system, but after that, we changed our system. So now Korean IP High Court hears not only the invalidity case, but also infringement cases. Okay, good. And I wonder whether the judges from patent court reluctant to give some preliminary opinion, aren't they?
Well, they used to do that all the time, like I said, preparing the hearing.
Yeah.
No, I can't really look into their minds, but really what we get is very good. It's very thought through, and it's, like I said, very helpful. And I think they're used to this kind of system of really giving their opinion at a preliminary stage. But it's always clear they're not bound by that opinion, so they can change if one party convinces them of a difference or that they've made a mistake. They will obviously consider that, and they're not bound by that preliminary opinion.
Oh. Very quick follow-up question then. Does giving the preliminary opinion mandatory to judges? Is it mandatory, I mean? At the patent court, yes.
Yes,
right.
It's Section 83, yes. It must be communicated at some point, or it shall be communicated after 6 months.
Interesting, yeah, system. Thank you. Okay, let's visit U.S. and Japan for this matter. Could you please explain your jurisdiction's approach concerning such motion, I mean the motion to stay? In other words, what is the customary judicial practice regarding the decision to stay the current injunction proceedings while an invalidity procedure such as IPR for the patent in suit is underway? Judge Chang first.
Yeah, so again, this is very much an equitable decision as well. So we consider a number of factors, and of course, first and foremost is whether granting the stay would simplify the issues for the court case. Sometimes it's a matter of number, and sometimes it's a matter of quality. So number, if the claims that are at issue in the IPR are just a small subset of the number of claims that are issued in the court case, then that would weigh against the stay, because there's still plenty to do in the court case, and we don't want to have to wait for the IPR to end. But if the claims, even if they are a subset that are issued at the IPR, are really the primary claims, the greatest number of damages arises from there, for example, then that would still be a reason to stay and wait for the IPR to finish. I should also mention that the courts do have the obligation to consider the defenses of invalidity. Right? So we are deciding that issue as well. So there is that overlap, which might also weigh in favor of a stay, to see whether the IPR results in invalidation without the court case needing to consider that. The status of the litigation is also very important. If our court case has moved forward in time and in effort a far distance, then I'm much less likely to stay. because I can see the light at the end of the tunnel. The goal line is there, and so I want to just get the case decided as soon as possible in that instance. And that is one reason why the district courts that have adopted local patent rules, we set a deadline by which the defendant must file an IPR petition so that you don't wait. And so in some courts it's 6 months and into the case, some it's shorter, some it's longer. But we want to require the defendant, do not wait till almost the end of the court case to then go file your IPR petition. And then lastly, of course, we are considering whether the patent owner typically would suffer undue prejudice, and is the defendant just trying to delay the case to try to continue, if there's no preliminary injunction, continue to allegedly infringe. So we consider that as well. I will say that the IPR system, those judges are examining they're experts, right? Like this is, very much, they have expertise in intellectual property law and the technology. So I do think many judges would like to see that advice from, because it does not bind the federal courts, but often those opinions are very helpful. There have been a few instances where I entered a stay, the IPR opinion was issued, and then I disagreed with the IPR decision, and now we have to start. We have to start again. But most of the time, I think the decisions are very well reasoned, and we like to defer to that expertise as well.
Okay, Judge Chang, thank you so much. I think Korean practice is very similar to yours, even though you have more delicate factors to make decision. Thank you. How about in Japan, Judge Shibata?
Yes. Under Japanese Act, the court can stay the proceeding, but actually, this seldom happens. Maybe in Japan, the defendant can assert the defense in injunction proceedings that the patent should be invalidated in invalidation trial proceedings. Therefore, in this situation, the defendant may assert this defense, and the court may examine this issue in the injunction proceedings. This is Japanese practice. So in this case, the court does not stay the proceedings.
Okay, Judge Shibata. As far as I know, in Japan, in 2000, there was Kirby case, right? And in that case, the Supreme Court of Japan held that the district court can make a decision about the invalidity of the patent in suit only if it is obvious to be nullified. Since then, has the practice relating to the matter been changed after that?
Yes. So after the Kirby case, the law was amended, and so the obvious elements are deleted. So I think nowadays, more than half of the cases, the defendant assert this defense. Mm-hmm. So the practice has changed very much.
Okay, thank you. I should start Japanese. Thank you. Next, let's move to the next question. Order of injunctive relief. I'm sorry again, Judge Klein. This question also goes to you first, because you made the decision. I'm sorry. The order, tenor, issued by this court in this case presents an intriguing aspect. While Claim 10 is about an apparatus, an injunctive relief did not specifically target the defendant's particular product. Rather, a broad or general injunction was imposed against any product incorporating the patented invention. It also contained threatening of fine of up to 150,000 euro or imprisonment, and just generally declared that the defendant is obliged to compensate all damages. That was very broad order, I think. Could you elaborate the form of order in the decision? Additionally, why didn't the court determine a specific amount of damage? And is it common in German court?
Okay.
Judge, please forgive me.
No, I'm very fine. We touched upon some of those subjects yesterday, actually. So like I mentioned yesterday, the tenor can be quite broad. It does depend on the plaintiff's praise that we get. And in this case, the plaintiff attacked all the products that complied with a certain standard, well, obviously manufactured and sold by the defendant side. So we found reason to believe that all the product, well, actually the standard, the patent was deemed to be standard essential, so all the products that would comply with the standard would be infringing the patent. So yes, the tenor is relatively broad. And as you mentioned, and I mentioned yesterday, if there is reason to believe that the defendant does not comply with the injunction order, then we will impose some coercive measures. And this is what this fine is all about in the possible detention. We will not automatically give it or impose it on the defendant, but only after an additional procedure, written or heard form, where the defendant has the possibility to defend themselves against those coercive measures. So it's a second proceeding. As to the damages, like I said yesterday and earlier, we do have a kind of a bifurcation system. In this case, again, the plaintiff only asked for a declaratory judgment concerning the damages. So we did not set a specified amount. We only established the general obligation of the defendant to pay damages at a later stage. And this is generally done in patent infringement cases. It's procedurally possible to ask both for an injunction and a specified amount of damages at the same time. And in copyright cases, for instance, it's done. But in patent infringement cases, because the calculation of damages is very difficult and can be quite expensive, actually, because you need an expert. And really, the injunction is the top remedy in the German system. So you will want to have a relatively fast injunction. And probably then it's advisable to just ask for the injunction and the declaratory judgment concerning damages. And, well, if it's needed at all, you will need to go to the damages proceedings at a later stage. Thank you.
Okay, thank you, Judge. You mentioned after the relatively broad injunction order, the second proceeding or trial will be followed, right? In that case, the judges from the second case will bear very heavy burden, isn't it? To make a decision whether it falls within the scope of the SCP or not.
In enforcement proceedings?
Yes.
Well, probably not, because you will look at a certain mobile phone, and then you will, we know in this case there was a certain standard debate between the parties. So what we will have to look at is, does the newly attacked mobile phone still use that standard? And if it does, well, it's pretty easy to decide.
Oh, okay. Oh, great. Thank you. Interesting. And then how about the damage issue? After the decision was made first, and there will be some second damage litigation, right? But between them, are there many possibilities to settle between the parties?
Absolutely. I remember we talked about this in great detail last year at this conference, actually. And last year I remember like under 5 cases of damages proceedings. And actually, the number has not changed, because in the last year, since I spoke last year here, there has not been an additional damages case. Those damages cases are super, super seldom. It's like one every few years. So I guess the parties, they will find a settlement at some point, and then they will just settle on the damages as well.
Okay, thank you. Thank you so much about your, explanation. Hi, Judge Shibata, I have some question to you. In your jurisdiction, how do the courts specify the prohibited acts or infringing products in an injunctive order? Is a recall order, like in this case, often awarded as a remedy? Moreover, is a claim for product destruction subject to a more stringent proportionality assessment than a claim aiming to prohibit the general action?
Yes, thank you. As I said yesterday, so it is common Japanese court practice that the target product is specified by the product name, and the target act is specified in the injunction. So, and next question is a recall. Recall is we can order recall, but it rarely happens. So it's very rare. Of course, if there's a necessity, the court can order recall, but I don't think it's not happen. And so yes, and if a product is found to be infringing, I think all the sale and the sale of the product is prohibited. I think the court may be ordered to that product to be destroyed. So as long as the target product is specified by the product name and it infringes, the court orders the destruction of that product.
Okay, for this matter, I think the Korean practice is similar to you. And okay, Judge Chang, I think U.S. has adopted very strong adversarial system, right? So in this matter, you might ask something to the lawyers, right? So this question goes to you. As you explained yesterday, in the United States, the injunction should specify the subject of the injunction. And right then, from your perspective, what do you think about the types of order in this case? Tricky question. Or if this case were filed in your jurisdiction, what would you ask the movement to do? And how could he or she meet the requirement of specification of injunction application?
Yeah, thank you. Well, and first, before I discuss how much more narrow U.S. injunctions must be, I have no doubt that the broad tenor of the order under German law is 100% correct. By rule, there is a requirement that the injunction in any kind of case set out in reasonable detail the acts that are restrained or enjoined. And then by case law, that has been interpreted by the Federal Circuit to mean that the injunction must specify the specific accused device or product. So the reasoning, I think, makes a lot of sense that if the additional device, even if not the same model, even if it is colorably different from the infringing product, still uses the standard. In an SEP case, that there's a lot of force to that logic. That well, then therefore this must also practice the patent and infringe. But after eBay, I think we would all federal judges are quite hesitant to issue some sort of blanket special rule for patent cases or for SEP cases. So I am, again, reluctant to say it without getting additional briefing, but I would be very wary of specifying an injunction that only refer to the patent itself without referring to the products.
And then you ask the attorneys bring another, right?
Yeah.
Bring
so
another specified document.
Right. The important
Briefing.
Yeah. The important issue then would be: is this next model or device colorably different from the one that was found to infringe and against which an injunction was issued? And it may be a very valid argument from the patent owner that this is not colorably different because it's practicing the standard, and so therefore it infringes. But again, I would hesitate to issue like a blanket rule in that situation.
Okay, great. Thanks, Judge. And then last, I'll give Judge Klein some time to rest for this matter. Okay. This question goes to 3 other judges. If very brief answer will be enough for us because we are running out of time. If this case were brought to your court and the facts remain identical, would you conclude that injunctive relief can be granted for the SCP holder Nokia in this case? Very tricky, but just, yes, briefly, we are the judges, right?
Yes, but as I said, I am hesitant to, so the answer is maybe.
Maybe, okay, great. How about Judge Shibata?
It's difficult, but maybe not.
Maybe not. Really? Okay.
Probably. I would conclude that the injunctive relief should be granted. I thought the ruling was very persuasive, so I thought I cannot see it otherwise. But the degree of specification might be different.
Okay, thank you, Judge Guan.
Sorry, but I changed.
Oh, really? Oh, wow.
maybe.
Yes, great, great. That's the favor of deliberation, right? We debate and reach a conclusion. Okay, great. Great. Congratulations, Judge Klein. Okay. Again. Okay. Actually, I wanted to ask some comment, but I want to skip this one for the audiences. Yes. This time, I'd like to open this floor to the audiences. Ladies and gentlemen, if you have any question directly to the judges, just raise your hand and briefly introduce yourself, and please proceed in English. And just specify who you are asking to. Nobody? Really? Okay, then let's go back. I'm sorry, Judge Klein. Would you share any additional comments or insights you might have concerning this decision? Yes, it was a very hard case, right?
It was a hard case. And actually, it was the first friend case or SAP case that we took in a new composition of judges. So for us, it was a very important decision, I think, to find some aspects of how we want to approach friend. And actually, you mentioned, Mr. Kim, that we would look more onto the defendant's behavior. And this has been a focal point of criticism about our jurisprudence. And at this point, I would like to mention that this is a decision taken by the Munich court in Germany, but we have several courts in Germany dealing with SAP cases, especially Düsseldorf, which is the most known venue in Germany for friend cases, and Mannheim, and they might take different approaches, although we have the Federal Court of Justice's decision. But clearly it's been mentioned to us, especially by defendants' attorneys, that we did not understand the Federal Court of Justice in the right way. So unless we have further guidance, it remains, remains slightly difficult to say what the Federal Court of Justice wanted to tell us. We obviously think, and I think, we understood them correctly. And I would like to stress that we don't try to be patentee-friendly or negative on the defendant, but we try to find the right approach of how to deal with friend issues. And like I said, it's my total conviction that it's the parties who need to set that friend rate. We could ask 5 experts, and we would probably get 5 different answers as to what is friend in this case. So really, it's all about negotiation. And this is what we're trying to achieve with our approach. But I do know that we're criticized. I totally stand by our decisions, totally. But I'm very happy to discuss all these issues, obviously. Thank you.
Great, great. Thank you, Your Honor. Yes, no question. Okay, I want to wrap this case here. And it's already 11:07, so I'd like to have some very short break. And we'll resume at 11:15 sharp. Okay? Great. Thank you, Judge. Thank you. Thank you. Okay, ladies and gentlemen, are you enjoying this session? Okay, okay, thank you. Okay, thank you for the judges and for our briefers. Okay, let's resume the session with topic 2, Microsoft versus Motorola. This case is also very interesting. And this briefing has been prepared by Mr. Jung Eun-hong and Sang Tae-jung. Mr. Hong, please.
Thank you, Judge Kim. Good morning, ladies and gentlemen. My name is Jung Eun-hong from Lee & Co. I'm deeply honored to brief you on this very important case, Microsoft versus Motorola, today. Due to the time constraint, please understand that I will focus only on explaining the essential content of the case. Okay. I will start by outlining the facts of the case. Motorola publicly stated its plan to license essential patents related to IEEE 802.11 wireless LAN standard and ITU H.264 advanced video coding standard on the RAN terms. Microsoft, the technology company known for products like Xbox, incorporated these standards into its products. In the chronology of the dispute, in October 2010, Motorola sent Microsoft 2 letters offering to license its essential patents at 2.25% per unit. Microsoft rejected that offer and filed suit against Motorola in the Western District of Washington, arguing the breach of its RAND obligations. In July 2011, Motorola sued Microsoft for patent infringement in Germany, and Microsoft moved its logistics operations to the Netherlands to avoid the potential financial losses in the event of a German court's injunction. In response, Microsoft filed its motion for a temporary restraining order and preliminary injunction with the district court to enjoin Motorola from enforcing any German injunction that it might obtain. The district court granted the temporary restraining order and preliminary injunction. After this ruling, Motorola appealed to the United States Court of Appeals for the Ninth Circuit, and the Ninth Circuit affirmed the district court's grant of an anti-suit injunction. Then the district court dismissed Motorola's injunction request and determined the RAND royalty rates as 0.555 cents per unit for H.264 patents and 3.471 cents per unit for IEEE 802.11 patents through the bench trial. After the bench trial, the jury found that Motorola had breached its RAND obligations and awarded Microsoft damages of $14.52 million. The Ninth Circuit affirmed the district court's decision on Motorola's breach and damages award. This case revolves around the issuance of an anti-suit injunction and explores whether seeking injunctive relief by a patentee declaring their patents as essential under RAND terms violates the duty of good faith and fair dealing. The suitability of the granted damages was also evaluated. In relation to an anti-suit injunction, Microsoft filed a motion for a temporary restraining order and preliminary injunction. A temporary restraining order is a brief injunction that stays in effect until a court hearing decides whether to grant a preliminary injunction. In April 2012, Microsoft was granted a temporary restraining order by the court, preventing the enforcement of German court injunctions. In seeking a preliminary injunction, a party typically needs to demonstrate their likelihood of winning the case. However, in the case of a foreign anti-suit injunction, the Gallo test is employed instead. The Gallo test assesses consistency between parties and issues across cases, determining if the outcome of the initial action addresses the matter to be enjoined. It also evaluates the harm to the forum's policies arising from ongoing foreign litigation and considers the impact of the injunction on comity. The party must also demonstrate significant harm in the absence of the injunction, a balance of equities favoring the injunction, and public benefit from granting the injunction. The district court granted Microsoft's motion for a preliminary injunction based on the following grounds. Firstly, the pending contract action is crucial in determining whether a German court can issue an injunction, as Microsoft is entitled to a worldwide RAND license for Motorola's SEP. Secondly, the German action jeopardized the forum's policy due to the potential for inconsistent judgments. The court highlighted that Motorola initiated the action in Germany 6 months after Microsoft's action, raising concerns about forum shopping and unnecessary lawsuits. Thirdly, the injunction wouldn't disrupt comity since Motorola sought resolution in a German court for an issue already before the US court. The fact that both parties are US corporations was also taken into consideration. The district court determined that Microsoft would experience irreparable harm without preliminary relief, taking into account the possible loss of market share and damage to its business reputation resulting from the German injunctive relief. In terms of the balance of equities, the district court favored the injunction based on the necessity to prevent substantial harm. The district court justified this decision, stating that Microsoft had to post $100 million bond to compensate Motorola in case the injunction is reversed or vacated. Furthermore, the district court noted that Motorola's letter implied their potential pursuit of monetary damages for their patents. The district court also demonstrated that an injunction is in the public interest because it would guarantee that SEPs are available to all prospective licensees on the RAND terms. Motorola appealed the case to the Ninth Circuit. Upon review, the Ninth Circuit upheld the district court's anti-suit injunction using the deferential abuse of discretion standard. Their decision was based on several reasons. First, the Ninth Circuit held that the pending contract action would be dispositive of the German patent action because it is evident there is an enforceable contract covering US and European patents. Moreover, the Ninth Circuit clarified that granting injunctive relief against infringement contradicted the licensing commitment, particularly given that the rent rate is meant to be determined according to the ITU standards. Furthermore, the Ninth Circuit found Motorola's German litigation to be vexatious or oppressive, suggesting that Motorola might be using the German action as a tactic to pressure Microsoft by threatening a product ban in a crucial European market. Lastly, the Ninth Circuit clarified that differing legal interpretations across jurisdictions do not create an intolerable comedy issue. According to the Ninth Circuit, this case, which involves a private dispute between two US corporations under Washington state contract law, raises no public international concerns. From now on, Mr. Chung will proceed to explain the issues of permanent injunctive relief and damages.
Thank you. Regarding injunctive relief, Microsoft sought for partial summary judgment dismissing the injunctive relief because Motorola's demand for royalties and its contract license to all commerce and rent terms are admissions of adequacy of monetary relief and the absence of irreparable harm. In response, Motorola asserted that the Supreme Court decision in eBay or rent assurances or Motorola's prior licensing do not provide a basis to deny an injunction categorically. Sorry. I will skip the legal standard for injunction as Judge Chang already explained in detail. In 2012, the district court held as follows. First, rent. Rent commitments create enforceable contracts between Motorola and the respective SSOs. Microsoft can enforce these contracts as a third-party beneficiary. Motorola's commitments to the SSOs require initial offers by Motorola to be made in good faith, but that initial offers do not have to be on rent terms, as long as a rent license eventually issues. Second, Motorola cannot demonstrate irreparable harm because at some point in the future, a license agreement for the Motorola's SAPs will become a reality. Because Microsoft will pay royalties under any license agreement, this license agreement will constitute Motorola's remedy. Third, Motorola cannot show that it has no adequate remedy other than injunctive relief. Motorola's remedy is a rent license agreement. Motorola's obligation to grant such a rent license far preceded the onset of this litigation. Fourth, the anti-suit injunction is no longer necessary in light of this order, which enjoins Motorola from seeking injunction against Microsoft. Regarding damages, Microsoft sought damages from Motorola's breach of contract because Motorola is contractually obligated to offer a license to any SAP's implementers. Instead, Motorola has failed and refused to offer a license on rent terms and initiated patent actions seeking injunction against Microsoft. The district court conducted a bench trial and found the rent royalty and its range for Motorola's SAPs. The jury found that the Motorola breached its duty of good faith and fair dealing by making offers far above the rent rates and by seeking injunctions against Microsoft, and then awarded Microsoft damages for relocating its distribution center from Germany to Netherlands and attorney's fees and litigation costs. The Ninth Circuit affirmed the district court's decision for the following reasons. First, the rates Motorola sought were significantly higher than the rent rate found by the court. Second, Motorola sought to capture more than the value of its patents by inducing holdup, and its infringement actions facilitated that strategy. The timing of the injunctive actions was also indicative of bad faith. Motorola's injunction suits were brought after Microsoft filed its breach of contract lawsuit with the district court. At that point, Motorola was aware that the lawsuit with the district court could establish rent rates. The Noor-Penningham doctrine, which shields individuals from liabilities for engaging in litigation, didn't immunize Motorola from liability for this breach of its promise. Where a party's injunctive actions to enforce a rent-encumbered patent violated the duty of good faith and fair dealings, the damages will be awarded. Shortly after the Ninth Circuit's decision, Microsoft and Motorola settled. Conclusion. The first, the preliminary anti-suit injunction. The first U.S. action is dispositive of the action to be enjoined. The German litigation is vexatious and would frustrate a policy of the forum issuing the injunction. The impact on comedy would be tolerable. Microsoft is likely to suffer irreparable harm in the absence of preliminary relief. The balance of equities will be tipped in Microsoft's favor. An injunction is in the public interest. Regarding the permanent injunctive relief and damages, a RAND-declared SAP holder cannot get injunctive relief against standard implementers. The damages will be awarded to include the attorney's fees and litigation costs and costs for relocating its distribution center in Europe, where a party's injunctive actions violated the duty of good faith and fair dealing. Thank you.
Yes, great, Mr. Hong and Mr. Jung. It was really great briefing for a very complex case. Ladies and gentlemen, I want to let you know again, the summary of case is at page 432 for Korean and on page 333 for English. Okay. By the way, judges, who will be the main speaker for this U.S. case? Okay, Judge Chang, you smile. Okay, thank you. By the way, before jumping into the issues, I just want to ask some very quick question. When I read some U.S. case or decision about SEP, Standard Essential Patent, you often call RAND, not friend. Don't U.S. citizens like friend? Why is that?
We do like to be fair. I don't know the reason why there's different acronyms. I think many judges actually do not. We dislike using acronyms because it makes it harder for readers of the opinion who are not specialists in the subject area to understand what is even being discussed. But I don't think there's any substantive difference.
Okay. Yeah. Anyway, they don't have any different connotation, the same meaning, right?
Not that I'm aware of. Yeah, I'm not aware of any.
Okay, thank you. And then let's start our discussion for this case. Judge Chang, you will open. Right. Okay. In this case, there appear diverse types of injunction. Yesterday, you already mentioned it, but just for the reminding. Would you please give us general explanation about the TRO, temporary restraining order, preliminary injunction, and permanent injunction, especially on the timing of filing, necessity of hearing, standard of proof? Just brief summary will be enough. Thank you.
All right. Yeah, thank you. And thank you, Mr. Hong and Mr. Jung, for the excellent case briefing. And I should also just note for conflict of interest purposes, I I own Microsoft shares. I bought Microsoft shares 30 years ago. And my wife worked as a Motorola software engineer some time ago. So I don't know where the conflict is. Maybe it balances out. But this case would never be assigned to me based on those conflicts. So to obtain a preliminary injunction, just briefly again, in addition to showing likelihood of success on the merits, the patent owner must show irreparable injury, inadequate remedy at law, meaning money damages would not suffice. The balance of hardships would favor an injunction, and the public interest would not be undermined by the issuance of a preliminary injunction. I do want to mention, beyond what I mentioned yesterday, which is that these preliminary injunction factors are often weighed on a sliding scale. And what I mean by that is, for example, a stronger showing on the likelihood of success on the merits might mean that the patent owner does not need to show as much irreparable injury or inadequate remedy at law. So it's a sliding scale of factors. At the preliminary injunction phase, the burden of proof is that the patent owner must show entitlement to the preliminary injunction by making a clear showing, not just preponderance of the evidence, not just more probably than not, but a clear showing. And then the permanent injunction factors are really very much the same. Obviously, you've now succeeded on the merits, but now the standard of proof is just a preponderance of the evidence that more probably than not the injunction ought to issue. Because you're no longer at the preliminary stage. Mm-hmm. And for the temporary restraining orders, just to briefly mention, that is the ex parte procedure where the other side receives no notice at all and the court just simply enters the order. That does require that the plaintiff clearly show that providing notice and an opportunity to be heard by the defendant will result in irreparable injury. And those can only last, for, as I said before, initially for 14 days, extendable for one more 14-day period, and then that's it, 28 total calendar days. And let me just also note, practically speaking, as I said yesterday, I do tell lawyers that their client's hair must be on fire if I'm going to issue a temporary restraining order without even letting the other side respond. And so even in that 14-day period, I will allow the defendant at that point to respond. And sometimes they're very well-resourced companies, and they are able to respond very vigorously and provide much more evidence. And that will sometimes lead to not extending the TRO.
Yeah, thank you, Judge. TRO is interesting to us, Korean, because we don't have similar system. Okay, thank you. Okay, let's move quickly to next question, again to Judge Chang for some procedural matters. There were two distinct facets in this case. A claim opposing Motorola's pursuit of injunctive relief and another claim seeking damages incurred in defending Motorola's injunctive actions. After the TRO and PI granted ASI, the district court rendered a partial summary judgment pertaining to the first facet on November 2012. In the US, our interim judgment that address only a subset of the claims, such as infringement or injunction issues, common in IP litigation?
It's not uncommon for district courts to decide a claim or a defense and enter a partial, we call them summary judgment, a partial summary judgment on a subset of claims or a subset of defenses before the case actually proceeds to trial. And those are instances where we find that no reasonable jury would be able to find in favor of either the claim or the defense. And so we remove that from the jury's consideration. So that does happen quite frequently, especially in intellectual property cases where there are many claims and many defenses. And sometimes it's an issue within a claim or an issue within a defense that we remove from the jury's consideration, because we are trying to make sure that the jury trial is as efficient and as possible, and consistent with the fact that no reasonable jury could find for the particular party in any event. So it is quite frequent that we will enter these partial summary judgments. Yeah.
Okay, thank you, Judge. Here I can find very interesting term used by the judges. I asked whether it is common, but he answered not uncommon,
Yes.
right? Okay. Thank you, Judge. Okay, let's visit Germany and Japan for this matter. In your jurisdiction, is it also common, again, for courts to issue interim or interlocutory judgment? More specifically, for example, do courts deliver interim rulings on matters of infringement or injunctions prior to the assessment of damages? You will, right? And what rationale underlies this practice? Are there any problems stemming from the issuance of interim order?
So I can say yes and no. Like I
Yes
said
or
earlier,
no?
no,
Okay.
both.
Your term.
Yes. Both. No, actually, like I said earlier, it's quite common that we only deal with infringement in first proceedings and later on in second proceedings with damages. But this bifurcation of the system depends on the plaintiff's prayers. It's very hard. There is a possibility to give something like a summary judgment in interlocutory terms, but this is really hard to achieve procedurally so that the higher regional court will accept it. So generally we have to decide on the whole set of claims on the whole prayers that the plaintiff gave to us, and only if the prayers in a way divided, we can decide on those matters. Thank you.
Okay, if the prayers contain not only the infringement but also damages, and isn't there any possibility of change of judges? Like, for example, you made a decision about infringement or not, but you are changed to another court or something like that. Doesn't that situation happen?
If there would be a second proceeding, yes, that's totally possible. But then in that case, well, we wouldn't have to go again into the question if the defendant is actually obliged to pay damages. We would just assume that because we already established that in the first proceedings, and we would move directly to the amount that has been set and asked for by the plaintiff. So there's a possibility that this personnel might change between judgments, but it shouldn't be a problem. But this is exactly the reason we may not give any interlocutory judgments generally. It's only if we really have a division made by the plaintiff.
Okay. One of the reasons why in Korea we do not deliver the interim orders not that often is that because of our rotation system. So the judges are reluctant to give some interim order because we might be transferred to another court after we make some decision about the infringement or not, right? Okay. How about in Japan, Judge Shibata?
So it is not common.
Not common.
Our court issue
Similar to Korea, right?
intellectual judgment. But the court sometimes deliver intellectual judgment. So the court may deliver intellectual judgment on intellectual disputes such as jurisdiction, or the court may deliver intellectual judgment on matters of infringement prior to the calculation of damages. In Japan, I want to explain the system. A plaintiff often seek an injunction and damages, and when seeking an injunction and damages, the court first examines whether there is a patent infringement or not. And if the court determines that the patent right has been infringed, a hearing will be held to assess the specific amount of damages. Mm-hmm. So we call it a two-stage trial. Before proceeding to the hearing on damages, interlocutory judgment may be made, especially if the defendant are not willing to proceed to the next stage, intellectual judgment delivered. And if the intellectual judgment are delivered, the court must make a final judgment in accordance with it, and the parties after that cannot make claims that contradict the intellectual judgment. So there are no more argument about this issue. So,
Judge Kwon, you think we have similar practice to Korea?
No, I don't think so. There have been suggestions to bifurcate the procedures, as in Japan, to decide on infringement and then to calculate damages. But in Korea, I would expect a huge amount of documents coming in to reverse the interlocutory decision first made. So Korean judges would be reluctant to make interlocutory judgment. However, in the Civil Procedure Act, there is a provision that the court could render a decision first on the whether it is infringed or not, and then to calculate the damages. Do you want to add? Yeah, no,
Judge
no,
Chang, do you have something to add? Oh, Judge Shibata, I'm sorry to interrupt you. Sorry.
So we call it two-stage trial, but often the judge only states orally that there is an infringement, and the court proceeds to the next stage. And usually, party doesn't make more evidence about the infringement. So I think it's very different from Korea. And if there is a possibility that the defendant is make more evidence, we deliver interlocutory judgment, and after that, the party cannot submit evidence.
Okay, I'm sorry. I think it's very important point to compare our practices, but I want to go to our main issues quickly. I'm sorry. Let's leave it there. Because it's anti-suit injunction is the main issue for this case. Judge Chang, in this case, when assessing the anti-suit injunction's impact on comedy, the U.S. District Court gave considerable weight to the location where the suit was initially filed, as well as the domicile of the parties, such as the places of incorporation and the place of patent registration. Okay, question. In this case, among Gallo test for ASI factors, which factors would be considered more important when contemplating the issuance of an ASI? And would the procedural stage or anticipated duration of proceedings in foreign jurisdiction have any bearing on the decision to issue an ASI?
Well, thankfully, there are not so many ASI suits or requests for ASIs that we have U.S. Supreme Court precedent on it. We do not have U.S. Supreme Court precedent yet on an ASI situation, but that does mean the law is still developing. I think the way that the Ninth Circuit and the District Court here approached it was that these factors are all to be weighed, and that there isn't any one factor that is more necessarily important than another factor in every single case. And of course, the court did rely on those factors, but on the issue of which case was filed first, right, I don't think that the district court there, and I would hope most district courts, are not considering where the first action was filed merely to say who won the race to the courthouse, like who got to the courthouse faster. You saw from the excellent timeline that Microsoft filed a lawsuit about 2 weeks or so after getting the letter, the offer from Motorola, and so Microsoft, they won the strategic, race to the courthouse. But as judges, that's not the reason why that's important. The reason why it ended up being important is because then Motorola waited almost 7 months to file the second action. And that suggested to the district court that the Motorola was just engaging in vexatious litigation because the same issue, at least as to the injunction, was already being presented to the district court in Washington. And so, yes, I'm sure Microsoft's lawyers advised Microsoft to move first and fast, and it, I'm sure, was part of their consideration. I would guess that it was part of Microsoft's consideration that they were filing the lawsuit in Seattle. Their corporate headquarters is there. But those strategic considerations are not and should not be important to courts. It was only because of this delay that to the district court it suggested Motorola was engaging in vexatious litigation. I think also choice of law was very important here, because the way the district court in Washington conceived of this case was that this really was a breach of contract case, and that the commitments that Motorola had made to the SSOs were binding contracts that Microsoft could then enforce as a third-party beneficiary. So the idea there is that, well, comedy would not be disrupted, or at least not be very disruptive, because at issue is a Washington state contract law, which the Washington federal judge, who very likely hears many, many Washington state contract cases, would be much more expert in than another jurisdiction's court. That's the idea. So I think that also played an important role, that the governing law ought to be decided by the court that is more expert in the governing law. And so again, that's not strategy, that's just the substance of the case. So I think all those factors were important.
Okay, thank you. Thank you, Judge Chang. Judge Shibata, you are the neutral judge between the US judge and German judge. This, sorry. Okay, that's all it. Okay, Judge Shibata, this question goes to you. Kind of tricky. What is your opinion in the US court's decision to grant Microsoft an ASI in this case? If this case were presented in your jurisdiction in Japan, how would you approach it, and for what reason? Would you grant the ASI against Motorola in Japan?
So there has been no Japanese judgment on ASI, so it's very difficult to answer these questions based on Japanese precedents. But this issue has discussed in Japan, and in Japan, it is widely considered that ASI has not enough ground under Japanese law. So ASI should not be allowed under Japanese law. So this is discussed in Japan. So the answer is, so if this case is brought to my court, ASI does not deliver. Reason is that it is considered that Japanese courts don't have the authority to suspend the effect of foreign judgments that are valid in that country. This is the reason. And also, so speaking of ASI.
Anti-ASI. Okay.
So there's no Japanese judgment, neither. But so it is difficult to say based on that precedent. But there may be several possible ways. So I think one is that ASI is not recognized in Japan, and filing for ASI overseas lead to infringement of Japanese rights. So ASI would not be recognized in Japan.
Okay.
That is one. But another way is that ASI would not be recognized under Japanese law because the content of the judgment are contrary to public policy. So there is no need to allow an ASI in Japan. So we don't allow judgment on tort. So based on because if the patent right has exclusivity, so if the defendants selling the infringing product, we can deliver injunction, but we can't deliver injunction based on tort. So
based on tort? What do you mean?
Tort.
Tort. Okay, tort. Okay, thank you.
So from this point, ASI is not delivered.
Okay.
Japan, so
okay, thank you.
There may be some possible cases.
Okay, thank you, Judge Shibata. Then maybe this conference might give you some opportunity to consider this ASI more deeply, right? And you might bring some change to Japanese practice later. Okay, great. This question goes to Judge Kwon. Actually, when you think about anti-suit injunction, the comedy will be handled very important, right? So this question is about the comedy. To what extent do you think international comedy should be taken into account when granting an ASI, just personally? And in the context of our case, given the Microsoft had avenue within the German legal system to both challenge Motoroola's injunctive relief through appeal and request a stay of execution upon its issuance, do you believe the U.S. courts could have rendered a different decision in deference to international comedy? What do you think?
Aside from my personal opinion, my impression is that many Korean judges would emphasize on international comedy. I was not aware of this case, but I recently discovered that there was a case on anti-suit injunction rendered by Seoul High Court. The court rejected the anti-suit injunction claim. That the reason was that it is due to the arbitration agreement that so the party can always file a suit according to the agreement. So and the court reasoned that it was not consistent with the agreement. And given the context of this case, where Microsoft had multiple options with the German legal system regarding German case, I think it is likely that Korean judges would favor respecting the decisions and processes of the German court. And I would end at this point.
Okay, very tricky question. Thank you, Judge Kwon. This topic is very interesting, right? So I want to go deeper. Judge Klein, in this case, the U.S. court granted an ASI against German court's injunction order, right? It may be very tricky question, but would it be enforceable in Germany? And I heard that with this ASI issue, anti-ASI has recently been granted in German court. And would you explain about this ASI issue in depth in Germany?
Thank you. So generally, the view that is taken by German courts is that anti-suit injunctions as well as anti-enforcement injunctions, they don't agree with our system. And there has been one decision that I found where it's not directly on enforcing the anti-suit injunction from abroad, but on actually serving the anti-suit injunction from abroad. And already this was denied by the court. So I guess it's probably likely that no German court would actually enforce an anti-suit injunction from abroad. Now, concerning anti-suit injunctions, this was actually a case that was, well, the facts were different concerning when the infringement case was filed and when a contract case was filed in the US. So first, this was a case decided by the Regional Court of Munich in 2019, the case of Nokia versus Continental. So first, infringement cases were filed in Munich and in Düsseldorf as well. And then later on, some months later, Continental, as a third party, filed a suit based on failure to comply with rent commitments under the SSO declaration in the US. And then sometime later, they filed for an anti-suit injunction. And against this, Nokia went to the Munich court and asked for an order obliging Continental to withdraw the application for the anti-suit injunction. This was later coined to be an anti-suit injunction. The court ordered this decision ex parte initially, and later on there was a hearing, but the court upheld the decision because they said, well, actually, this can be a patent infringement from another point of view in Germany, because patents are not only protected by the Patent Act in Germany, they are also protected by German tort law. And so if you're based on a patent, you get an exclusive right. And where you are excluded to, to use your exclusive right, then this could actually be a violation. The court held that here, where you are barred from going to court by this anti-suit injunction, indirectly, because you could be liable to pay a lot of fines, actually, there could be penalties, then this could actually mean that the patentee is barred from going to the court. And this is the only chance he has to defend his intellectual property, obviously. So this was the reasoning of the regional court. The higher regional court of Munich upheld this decision with a slightly different reasoning. It's very dogmatically, the subject is super interesting, but I will focus on the pragmatic issues here. And it's important to stress that also the courts of Düsseldorf, and as far as I know, only Munich and Düsseldorf have been concerned with anti-suit injunctions, also in general respect and accept the possibility of anti-suit injunctions. Later on, we did have, like 2 years back, we did have 15 cases, I think, 15 requests for anti-suit injunctions. Now the case number has dropped significantly. But we also decided on like 4 times A, anti-suit injunctions. Because there was the possibility that actually our defendant in the German case would actually go against our anti-suit injunction abroad to get an anti-suit injunction. So we decided, yes, also in 4 times A injunction can be ordered. So nowadays the case numbers have dropped, possibly because both Munich and Düsseldorf held that a patent user who asks for an anti-suit injunction abroad would be deemed an unwilling licensee under Friend. So to really to be able to have a successful Friend defense, it might be possible that patent users would not ask for anti-suit injunctions in the first place, so we don't get as many anti-suit injunction requests in the end. Now, concerning comity, one point I would like to stress is, and that will be the end, that we don't view the actions that the courts take in the US, for instance, as the problematic thing, but rather what we deem a violation of the patent is the request from the patent user to get an anti-suit injunction. So it's really nothing to do with the courts, it's basically the patent user's action that we deem a problem. Thank you.
Okay, yes, yeah, I'll give you the opportunity. Okay, anyway, just wait a second. Okay, thank you so much. Your in-depth explanation. Yes, it seems like a battle, but I cannot visit the U.S. Okay, follow-up question first, Judge Chang. You can add something to the answer. In this case, based on Judge Klein's answer, the injunction cannot be executed in Germany, right? The U.S. decision cannot be executed in Germany, right? And so this question goes, in this case, do you think Motorola is able to proceed to execute German action injunction against Microsoft in Germany because the U.S. court's ASI order would not be enforced in Germany? Is there any possibility like that? Or what would happen in the U.S. if Motorola visit to German court again to seek an anti-ASI against ASI order in the U.S.? Maybe Microsoft filed a contempt motion in that case?
Yeah, exactly. Yeah, and I want to emphasize as well that this is not a dispute between the courts.
Okay.
This is it's still a dispute between the parties, and right. So as a formal matter, but importantly formal matter, the anti-suit injunction that the district court in Washington issued operates against Motorola. It does not operate against the German courts, and so it operates against Motorola. And so if Motorola were to have then tried to pursue additional relief in Germany, then the district court could have convened contempt proceedings, and my guess is Microsoft would have moved for contempt of court against Motorola. So it is not a dispute between courts, and I think so that is important to emphasize. And I also think this is why these conferences are so valuable, because the fact that we have anti-suit injunctions and then A squared suit injunction, A cubed, and then A to the 4th power, shows that this is an issue that we do need to try to coordinate with, all with the view of not helping out one country over another or one economy over another, but all towards the view of what is best for the law in the case, and who is more expert on the governing law, and and which court might be more efficient because they are more expert. Those kinds of substantive concerns, and not concerns about one economy over another.
Okay, thank you so much. It was very hot debate. So let's move a cooling question. Very short answer will be predicted. This question goes to 4 judges commonly. To what extent does your jurisdiction consider the likelihood of success on the merit when issuing on preliminary injunctions? Could you approximate the likelihood in numerical order? Is it possible? Very quickly. Who will open? Okay, please.
No, as I said, the plaintiff does need to show likelihood of success in order to obtain preliminary injunction, and must show that as a clear entitlement.
Clear entitlement.
Clear entitlement, 72.8%.
Sorry? 70?
It's a joke.
It's very important to
it's
studies,
more,
right?
more. It's higher than preponderance, which is more probably true than not true.
Okay.
But we don't. Yeah, it's not 72.8%.
Okay. Yeah. How about in Germany?
Oh, well, like I said yesterday, we really go into the depth of things, and the threshold is pretty high.
Pretty high.
Yeah, and we don't have to have a merits case yet when we decide the preliminary injunction, so really there's no clear correlation between those two.
How about in numerical order?
I'm sorry?
Could you give us some number?
No. We just look into the preliminary injunction if you're convinced by that.
Okay, right. So you should consider 4 factors before you should also not just one factor consider, right? Okay, I understand. How about in Japan?
So preliminary injunction is a prima facie case, but the severity of the impact of the preliminary injunction, the likelihood of success on the merit, is very high.
Very high.
High.
Did you say high or very high?
High.
High.
Very high.
Okay. Okay. How about in Korea?
It's very challenging to numerically quantify precisely, but I would say over 80%,
Over 80%,
would be
wow.
necessary. And to add to about a tripled, quadrupled, and injunctions, there is I found a scholastic paper that only even number A suit injunction would be allowed in Korean. Yes.
Hey, Judge, 80, the number is just your personal.
Yes,
right?
it's only my personal opinion.
Okay, let me summarize. From
I
US,
need to clarify.
Okay, so from US, clear, right? And from Germany, pretty high. In Japan, and high. And in Korea, personally, 80%, something. Okay. Yes. Great question. Great answer. Thank you so much. Actually, this session is focusing on injunction, but I cannot revisit this issue, damages. It's very important for every case. So let's start with the question to Judge Chang. The U.S. court's ruling that Moller's rent commitment constituted contractual obligation, with Microsoft being the third-party beneficiary, seems to have played a pivotal role in denying Moller's injunction request. To my knowledge in the US, however, rent commitments made to SSO are not always construed as establishing a contract per se. And interpretation often depends on specific circumstances and the policies of the SSO in question. And Judge Chang, could you elucidate the specific circumstances that determine the establishment of contractual obligation in this case?
Yes, I think here the district court was looking at really 2 categories of evidence. One is how clear was the upfront commitment, like the commitment to the SSOs, and then the second category is then how clear was the assurances that Motorola gave to the SSOs. So what did the SSOs demand, and what did Motorola then commit to the SSOs? On the first category, the SSOs required. They made it very clear that before we establish the standard, the patent owners must license, the patents, and so that was very clear to the district court. And then in the second category, the district court again read what Motorola committed to the SSOs, and for one of the SSOs, the commitment was Motorola is prepared to grant licenses. And then in the other commitment, the Motorola just flatly said, we will grant licenses. And so I think both were so clear to the district court that the district court even took that away from the jury. They did not send that issue to the jury at all. They decided before any trial that a contract had been formed between Motorola and the SSOs, and then concluded that, well, that Microsoft is the beneficiary. They're the potential licensee. So the entire contract is formed to benefit others, and here that would be Microsoft. So it is true that we would apply general contract law. We would look at the text of the commitment required and then the commitment itself from the objective reasonable person standard. And here the judge concluded that it was so clear that no jury could find otherwise.
Judge, let me clarify your comment about this matter. Actually, the commitment is made between the SCP holder and SSO, right?
Yes.
And what's assurance? Assurance isn't it similar to a commitment? Assurance.
Yeah, right, but I think what the district court relied on here was what did the SSO demand of patent holders, and it was very clear. And then what kind of assurances did Motorola make to the SSO?
Ah, okay,
yeah,
okay.
Those two different, they're slightly different. Yeah.
Okay, then follow-up question goes to Judge Chang. Then do you think the clear term of undertaking led to the finding of contract for the third-party beneficiary, right? You think like that?
Yeah.
The clear term, yes, led to that. Then aren't those terms will grant, the SCP holder will grant, or they are prepared to grant? Those kind of terms, isn't it common in the commitment?
You can argue that. Yeah, I mean, and you know, the is prepared to grant does sound a little different from, you know, will grant. But again, the SSOs up front, you know, were clearly demanded, you know, that the holder of the SEP would grant licenses. And so I don't think you know, judges would look kindly on an argument that from Motorola that, well, we weren't as clear in our promise, even though the SSOs clearly demanded, you know, this kind of promise, and to just kind of massage the language of their commitment, I think would have been a problem.
Okay, thank you, Judge. Let's visit Germany, Judge Klein. In your jurisdiction, how are SCP holders' RAND commitment interpreted with respect to injunctions? And based on the facts of our case, could you share your perspective on the decision in this case to withhold injunctive relief from Motorola as an SCP holder?
So, first of all, we do share that the opinion that commitments to SSO might entail contractual obligations, always a question of the special circumstances of the case. And we will always examine very thoroughly if these commitments actually go further than the antitrust commitments. So we decided on some ETSI case, and IEEE case might be published soon. So we will usually, the discussion between the parties and the court focus on the antitrust issue, let's say it like this. In this special case, well, like I said, we would focus on this negotiation model probably, so I might actually need more facts as to what was happening between the different parties to decide if I would withhold the injunction. But, well, it's a pretty high bar, usually.
Okay, thank you. How about in Japan, Judge Shibata? Could you give us some brief answer?
Yes.
It's not that, there are not that much cases, right?
Yes. So,
okay, I understand.
Yes, so, I have to say that this is not clear under Japanese. But I think in Japan, negotiation process might be examined more. But if these factors are considered, must be considered. But there is only few cases in Japan, so it's very difficult to say this issue.
Okay, yes, damage issue is now, I'll give you the damage issue. As you heard at the case briefing, on the basis of breach of contractual obligation, the U.S. court directed Motorola to compensate Microsoft for its relocation cost in Germany. Judge Chang, right? And if you were to adjudicate this case, but not Judge Chang, the three judges, if you, the three other judges, were to adjudicate this case, do you think that you would reach a similar conclusion? The damages issues, the relocation cost should be compensated? What do you think about this, Judge Kwon?
Okay, I'll take it. In Korea, damages are understood as the financial difference between where someone would have been without the unlawful act and where they are now after the act took place. So in line with this principle, if I were to, or maybe other Korean judges would also adjudicate that relocation cost, as in the United States decision, should be compensated.
Oh, do you think so? Okay. Oh, I slightly have some different opinion because this relocation cost could be assessed some damages arisen from some special circumstances, right? In that case, our Civil Act says only if the obliger had foreseen or could have seen that kind of damages could be compensated.
Yes, I would add that what's the essence about tort or damages are debated in Korea.
Okay, thank you. How about in Japan?
The law is same. So this is a special circumstances. So the party did foresee or should have foreseen the circumstances. So, in this case, question may be whether Motorola foresaw or should have foreseen that Microsoft would relocate its distribution center when Motorola takes action. And I think deciding this matter, we need to more facts. For example, more relevant facts maybe need possibility that Microsoft changes the product configuration or the function and necessity of its distribution center. So I think more facts are needed, and I think it is possible that the Japanese court would reach a different conclusion based on some added facts.
Yeah, so in summary, you might think is some damage arisen from some special circumstances, right?
Yes.
Yes,
So this is
you might reach some different conclusion.
Yes. So if there are some, so it depends on the matters, what facts. So, but it's possible.
Okay. How about in Germany, Judge Klein?
We basically have the same situation like in Korea. So we compare a hypothetical situation with the actual situation. And based on that, you could probably just say, well, yes, the damages were incurred. But we would probably, if the defendant raises that issue, look into the question of contributory negligence. So if the damages that were actually occurred were extremely high and maybe not necessary to actually stop a certain damaging situation, then we might limit the damages that should be paid. So I would need more facts as to what the situation would have been had Microsoft not relocated as to compare to where it did relocate.
Okay.
I think I missed one thing.
Okay, thank you.
So I took it so hurriedly. So we should consider whether Motorola could expect or this could happen. So this would be considered importantly.
Okay, great answer. Thank you, Judge Kwon. Okay, we are running out of time. Okay. Already, I want to get some comments from the judges, but I want to skip it to open the floor to the audiences. Is there any gentleman or lady to give some question to the judges? It's a very honorable chance. Yes, Judge. Yes, yeah. Judge Wu, yeah. But not to me, to the judges, right?
Thank you for your wonderful presentations and discussions. It's very, very memorable and monument session. I really appreciate. And my question is, I think that the key issue in both cases was whether the parties complied the friend obligation or breached the friend obligation. I interestingly noticed that the standard about whether the plaintiff complied with or breached the friend obligation is somewhat different. In the German cases, I noticed that the wording is that the offer was completely unacceptable, very high standard. Instead, in the US cases, I think that it must be the good faith offer or the significantly higher or not. I think there is some discrepancy between two wordings. Could you explain or give some explanations?
Well, yeah, I mean, because this is conceived as a breach of contract, it could vary from state to state to state. So I don't know what the law would be in all 50 states. I would say that I would be skeptical that completely unacceptable is the standard that we would give to the jury, because the question is whether or not Motorola breached its duty of good faith and fair dealing. And so we would give certain factors to certain considerations for the jury to evaluate whether or not there was a breach of the duty of good faith and fair dealing, including what the fair rate would be, which is here the judge decided that, and so the jury had that information. But also the course of the negotiations, and were they responding to each other, or as in the Germany case, if APA waited many months before responding. So those kinds of factors we would look into. I would be very skeptical that any state contract law would require some kind of showing of that it was completely unacceptable.
Yeah. Okay. Judge Klein,
very quick. Just to make sure that this is understood correctly. It was in the brief case briefing. So we will need the parties to negotiate. The defendant needs to answer an offer as long as it's not completely unacceptable. But that's not the end point of discussion here. If we find that the defendant did not answer in time or correctly under his friend obligations, then we will deem him an unwilling licensee. And in this case, it's not necessary to look into the offer further. But this is not the end point for the offer to decide if it's not enough just to give an offer under friend obligations that's not completely unacceptable. It's just that it's the starting point. This offer must be the starting point for negotiations. So we would not stop at this point, but we would, at some point, we would look further into the offer, actually.
Okay, I think into the whole process of the negotiation, right?
Yes.
Right. Okay.
Okay, I think it was really great question. Actually, I found very interesting thing from this case. It was that contractual obligation defense was raised not only in the United States but also in Germany. But in the United States, it was successful, the contractual obligation defense. But in Germany, they failed. So it is very interesting, right?
Well, the contractual obligation was not made to the court. They discussed that before they went to court, and then, it was not raised as a defense.
Sorry, Judge. I'm mentioning the Mannheim Court's injunction case. Yes, not your decision. Okay, yeah. So it was very interesting. Okay, closing remarks. Okay, finally. All right, we completed all the issues prepared today. I hope this session has given us precious opportunity to enhance our knowledge about IP injunction practices among the countries, right? And I also, again, want to express my deep appreciation to the judges and our case briefers for their sincere dedication to our session. I think for judges are going to grant the injunction restraining me from continuing this long session. Okay, Your Honor, no objection, I obey. Thank you. Thank you all.
Thank you very much. And this concludes the final session of this conference. Please give a big round of applause to the moderator and speakers. Thank you.